Hello, that pops from legal reform. Legal reform is just simply a page that gives you a whole lot of laws that aren't talked about and even less used. Okay, so I spoke to many people about this, so I'm going to go over it again, okay? And I'm going to use one of the memes that I use on my page. Okay, State's Attorney, I demand you exonerate me because I have exculpatory evidence. Rule 3.0 of the Rules of Professional Conduct says that's your job. You know the rules, and so do I. Okay, let's go to the rules. Okay, I'm using the ABA version. Okay, Rule 3.8, special responsibilities of prosecutor. I'm using the ABA because the ABA is the Model Rules of Professional Conduct, which is required for every state to use, and they can build on it, they can enhance it, give it bite, make it so there's no legal loopholes. There's no such thing as legal loopholes. That's like saying, when the Play Store puts an app and it has a back door where somebody can steal your identity, no, it's not legal. Okay. So Rule 3.0, special responsibilities of a prosecutor. Let me remind you that I'm using the ABA because a lot of states removed Rule 3.8, and that's in the interest of the bar. That's not in the public interest, which is a violation, not just of the Rules of Professional Conduct. Remember, Rules of Professional Conduct, the Code of Judicial Conduct, is guaranteed to you through the Sixth Amendment of the U.S. Constitution, effective assistance of counsel. Okay, so, basically everybody has to do this, Okay, Rule 3.8, special responsibilities of the prosecutor. Prosecutor in a criminal case shall. Okay, and I'm just reading it. I didn't write this, so people argue with me, but they're arguing the law. They're arguing the written law. They're not arguing with me, and they thought themselves some kind of genius, but when I give them the law, they always shut the hell up. And the same thing happens when I talk to lawyers. The prosecutor in a criminal case shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. People, that's why I tell you in every criminal case, it's mandatory it start with a probable cause hearing. If there's no probable cause hearing, it's thrown out that day. A very astute judge in Texas has been throwing out cases on no probable cause. Cop saying he arrested some guy for resisting arrest, and the judge wanted to know why was he being arrested. Well, I told him to get out of the car, and he resisted, but the judge threw it out, no probable cause. But he did not cite state's attorney for violating Rule 3.8. Okay, refrain from prosecuting charge the prosecutor knows is not supported by probable cause. Make reasonable efforts to ensure that the accused has been advised of the right to and the procedure for obtaining counsel and have been given reasonable opportunity to obtain counsel. C, not to seek to obtain from an unrepresented accused a waiver of important pretrial rights, such as a right to preliminary hearing. So you're going to want to look at a preliminary hearing and the grounds and the workings behind that, because that doesn't happen either. What's supposed to happen doesn't happen, and it's simply because you don't know the law. Okay, make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigate the offense, and in connection with sentencing, disclose to the defense and the tribunal all unprivileged mitigating information known to the prosecutor, except when the prosecutor is relieved of this responsibility by a protective order in the tribunal, which they're not known to do. In my case, there was one case where the state's attorney said I served a 10-year sentence and I had just gotten out of jail, which was wrong. I did a 2-year and 10 months in Pontiac Correctional Facility, maximum security, Illinois, and Originally started with a really, really big sentence, and I don't know, 18, 20 charges, which violated my right to, which they violated, the double jeopardy clause. You can't charge a person, prosecute a person multiple times for the same crime. And they knew I wasn't even involved in a crime, so they didn't want the cop testifying, because out of the 100 witnesses, he brought the only ones that said it was me, when everybody else said I'm Mexican. I was a teenager. I was a kid at the time. They said it was a grown adult male, full beard, big bushy hair, Caucasian. Okay, mitigating information, responsibility, protecting the order of the tribunal. Okay, E, not subpoena a lawyer in grand jury or other criminal proceedings to present evidence about a past, present client unless the prosecutor reasonably believes the information sought is not protected from disclosure by any applicable privilege. The evidence sought is essential to the successful completion of an ongoing investigation or prosecution, and there is no other feasible alternative to obtain the information. F, except for statements that are necessary to inform the public of the nature of the extent of the prosecutor's action and serve a legitimate law enforcement purpose, refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused, and exercise reasonable care to prevent investigators, law enforcement personnel, employees, and other persons assisting or associated with the prosecutor in a criminal case from making extrajudicial statement that the prosecutor would be prohibited from making under Rule 3.6 of this rule. When a prosecutor knows of new credible evidence and material evidence creating a reasonable likelihood that a convicted defendant did not commit the crime of an offense of which the defendant was convicted, the prosecutor shall promptly disclose that evidence to an appropriate court or authority, and 2, if the conviction was obtained in the prosecutor's jurisdiction, promptly disclose that evidence to the defendant unless the court authorizes delay, and undertake further investigation to make reasonable efforts to cause an investigation to determine whether the defendant was convicted of an offense the defendant did not commit. When the prosecutor knows of clear and convincing evidence establishing that a defendant in the prosecutor's jurisdiction was convicted of an offense the defendant did not commit, the prosecutor shall seek to remedy that conviction. Okay, see, that's it. Rule 3.8. And I've helped plenty of people in criminal cases. When I first found the rule of professional conduct back in 1979, it put me on a mission. Okay, and my mission was to help my people, we the people. When I took a Pledge of Allegiance to the flag, I took a Pledge of Allegiance to what the flag stood for, the U.S. Constitution, and who it was meant to represent and protect. We, the people. And that's why my heart is so much in this. Not just because of what happened to me, it's what's happening to we. You know, just because it happened a lifetime ago doesn't mean it stopped happening. It's still happening, and I find it rather disturbing. All right, that nobody in a court of law is abiding by the rules of professional conduct and the code of judicial conduct, which is denying you due process, denying you a fair trial. You know, and you don't need to state all those to have your case over. Just one violation of your constitutional right is cause to overturn your case, have it reheard, or have it dismissed. Most people don't know you being deprived of a quick and speedy trial is grounds to have your case dismissed, thrown out, or reheard. Now look up a quick and speedy trial in the state of Illinois. It's 90 days, and that don't happen. Okay, so you should really get on this, you know. I mean, even if it's not a criminal case. Remember, this is a special rule for prosecutors. All the rules apply in every court, but this is a specific one only for the prosecutor, okay? Whether it be the state, federal, whatever, you know. in any criminal case, this is a legal obligation of the prosecutor. Okay. I have some more to do really quick. Yeah, I'd like to get back to you, but you really got to understand this. Okay, so I forgot which states took out this rule, but you'll see. Look up your state's rules of professional conduct and compare it with the ABA, and you'll find out how limited the legal, or how limited the legal system is when it comes to due process. It's dumbfounding what they do. So remember, them not doing this, abiding by the rules of professional conduct and the code of judicial conduct, and I strongly suggest you hold them to the letter of the law when it comes to it. Otherwise, they're going to tell you it doesn't mean what you think it means. These words don't say that, and they're going to try to tell you what it means to them. That's devoid the letter of the law. That's illegal. Okay? It tells you that in the preamble of the rules of professional conduct. Don't forget to look up the code of judicial conduct as well. That way you'll know what to expect or what should happen before you step in front of a judge. And if you're smart, you'll go over the rules of professional conduct and the code of judicial conduct in the court with the judge and the lawyers, especially if you're on Zoom, so everybody, gets an idea how things are supposed to go, okay? I'm doing my best. I've been doing it, like I said, since 1979. And they took out a couple things, I guess, because I started filing paperwork as soon as I got out of prison. Shortly after, I went out and had a bit of a good time. Met a few ladies, had a few drinks, and first couple months was. But after that,
why won't you answer me? Hello, this is your cell phone.
Sorry about that spam call. But either way, this isn't happening. It needs to happen. I've already had talks with the FBI, the Department of Justice. I'm going to have talks with the Illinois Attorney General, who said they're going to assist the Cook County State's Attorney's Office with overturning wrongful convictions. So I'm going to do that. Okay, and I have more than exculpatory evidence. What I have is a proof of a conspiracy against rights under the color of law. Look that up. It's a legal term. It's a conspiracy. You know what that is? To deprive rights, to deprive you of your constitutional rights under the color of law. And look up under the color of law. That means that's just stating that, you went through something that you think is legal, but is actually illegal because what happened was against the law. It's just that you didn't know the laws, so you didn't know that it was against the law. Just look it up, the color of law. It's a beautiful thing. Let's see if I get it up here real quick. There's a lot of things about the color of law. These people did a far better job than I could explaining it. The color of law, forgotten history of our government, segregated America. Okay. What is the core argument of the color of law? The core argument of the color of law is law enforcement officer cannot abuse their position of authority by infringing on the rights of individuals. And you see cops do that all the time. They make up laws and for some reason they don't have to know it. What is the thesis of color of law? Okay, the author argues that intractable segregation. What is the difference between, what is the color of law in simple terms? Okay. which state action it referred to an official whose conduct was so closely associated with the state that the conduct was deemed to be action of the state, which they're referring to in the preamble where it says no laws can be made in the interest of the bar. Everything must be in the public interest, not in the interest of the bar or a parochial interest in the interest of the church. Okay, making laws in the interest of the church is totally illegal. Read the rules of professional conduct. It's in the preamble. Okay, I'm Christian. I'm a Catholic. Hey, I love my religion. I have my faith, but I am not going to inject that into someone else's life. I have a respect for other people. Respect given is respect earned. Okay, why is it called the color of law? The term color of law was first used in English statutory law in the 13th century, originating for the fact that soldiers and officials of the crown, basically they were above the law. No laws accounted to them. So they would hold laws against you, but it didn't count on this, so that's the color of law. There's so many questions you could ask. Okay, but the main thing is that what you're going through is a conspiracy to deprive rights under the color of law. Okay? Thank you and good day. On to the next video. I got something else to talk about.